So we're here to talk about the rewards and challenges of being a judge. And I think the theme here is there are a lot of challenges, and particularly in this political climate, there are a lot of challenges. But at the end of the day, it's really a great job. And I hope as many good, qualified, hardworking people will apply to be a judge as possible. So that's sort of the theme, and we've got a bunch of things we want to talk about. The first step in the judge process is the application process. And I want to talk about that, but I wanted to sort of give everybody a little bit of a perspective before we do. So, as you know, we have the governor's committees are set up per district. The composition of that has changed recently, and there has been much discussion about that. And candidly, I like the system that was in place when I was appointed 14 years ago. But it's not the end of the world that we have this different system set up. I hearken back to when I started as a judge in the late 1980s, and looking around, I think some of you probably weren't born then, which makes me feel kind of old. But basically, whatever process was in place then, I'm not sure what it was, but the end result was that people, lawyers, who were looking for sort of an ease into retirement and who knew the governor got the job. And the job was a very different job, and I apologize to those people now, but it was a very different job. And I don't think that bench could hold a candle to the current bench that we have. It's a very different world. We have not gone back to that. So keep that in mind. Yes, some things have changed, but it's not that dramatic a change. The other thing I wanted to point out is that I know that there's been a lot of criticisms of the new nominating selection process. And that's fine. Everybody's entitled to their opinion. But I will tell you, on the 3rd District bench, in the last few years, the folks that we have gotten have been terrific. They are qualified, they are hardworking, they are diligent, they are bright. So, let's sort of let's be less dramatic when we're talking about this stuff, and just keep that in mind. Patricia, you're the most recent, literally the most recent person appointed to the judge. What was it like going through the recent application and interviewing process?
Sure. So the application itself, and I encourage everybody that has any potential interest in applying for a judicial position to go online and see what is in the application. It's really a fairly straightforward application that just wants to know about you as a lawyer, your experience, and why you want to be on the bench. From the time I started that application until my appointment, I made the decision that if I was going to do this, I was going to do this as myself, for better or for worse, right? I'm not a perfect human being, but I wanted the people that read my application and those that interviewed me to get to know me and hopefully know who I would then become if given this opportunity. And throughout the entire interview process, so I had 2 interviews with the Judicial Nominating Commission for the 3rd District, and I got to meet the governor's staff several times for interviews, and then ultimately the governor himself. I felt that the questioning was completely fair. The questions were designed to get to know who I was, what my practice had been, my views on sort of judicial philosophy, what fairness and justice were. And perhaps my favorite question, and I think this one was from the governor, was, tell me about a time you've made a mistake and what did you do about it? The questioning to me was not political. It was all focused on getting to know who each individual applicant would be if given this amazing opportunity. I sound really positive about it now. Let me just say to everybody, I was scared, just like everybody else would be if you went through that process too. But that fear was my own. It wasn't created by anybody that had interviewed me or by any of the questions.
How many times had you applied?
I applied twice.
Okay. All right. Don, I guess I should be more formal. Judge Torgerson, what can you tell us about the process in the rural districts?
The process is the same. We have historically fewer applicants. Being a rural judge is the best kept secret in the state, so you should apply for rural positions. It really is a great job. There are fewer applicants. I have a note here. Does everybody know everybody? The answer to that is no. My district covers a quarter of Utah geographically. And so drawing from 4 really diverse counties, we're 5 hours apart from one corner to the other by car. So it's the nominating committee is drawn from all 4 counties in my district. And so I'm trying to remember who was on my committee. I think I knew maybe 1 or 2 of the people, but not the committee generally. So I think it's the same process, just fewer applicants overall.
Justice Hagen, any thoughts from the appellate perspective on the application process?
Well, there are usually a lot of applicants at the appellate level, and I was not nearly as lucky to apply only 2 times. I think most people have heard my story that I applied 8 times for the Court of Appeals before Governor Herbert appointed me. I decided that if it was really something I wanted, I wasn't going to give up. I was going to keep at it. And I was really grateful to be appointed. And then I was absolutely stunned when I was appointed to the Supreme Court for the first opening that opened after I was on the Court of Appeals, because that had not been my prior experience with the appointment process. But I thought that it was a really rigorous process. For the appellate court, there are additional interviews. Usually the senators on the Judicial Confirmation Committee want to have one-on-one sit-down lunches or coffee with you, usually with a member, well, always, in my experience at least, with a member of the governor's staff present. And then there are usually 2 confirmation hearings, and they are very detailed, going into every decision that you've made and those types of things. So it was a very rigorous process. I agree. At the time that I was appointed, I did not feel that I was asked any questions that were inappropriate, none that would violate our constitutional prohibition on using partisan political considerations in the appointment of judges, and I thought that they were fair questions. So it was a good experience for me.
I would point out, anybody thinking about applying, it is not uncommon to have to go through the process 4, 5, 6 times.
8's really pushing it, but.
One of the challenges these days of being a judge is the workload. I will tell you, it's not an easy job. And I was at a CLE like this about 10 years ago, and we talked about should people apply to be a judge. And I remember the 2 things that I wanted to point out was, number 1, don't apply if you think it's going to be an easy sort of strolling into retirement, because it's not. It's a hard job. I think the first 6 months of this job is the hardest thing that I've ever done. I mean, the learning curve is steeper than you can ever imagine. The other thing that I tell people is if you sort of wear your politics on your sleeve, if you consider yourself sort of a social justice warrior, this is not the job for you. You will be very frustrated, because our job is to follow the law. And there are lots of laws that none of us really particularly like to apply, but we do because it's our job. And so, I would keep that in mind. Given the challenges that it can to be a judge, to the workload and everything else, does anybody have a perspective? Judge Torgerson, you've been on the bench for how many years? 10 years? 8. Any thoughts on that?
Yeah, I think it depends on the week how much there is, but it definitely at times is feels pretty heavy. I think overall, people who are appointed to judicial positions tend to be the people who were putting in the work anyway before they took the bench. So I think it's familiar to the people who are on the bench what the work looks like, but it's definitely not a coast into retirement.
Judge Kuendig, how many weeks have you been on the bench now?
A whole 4 weeks.
Wow.
Yes.
Does the fire hose seem like it's on full throttle?
The fire hose, I didn't even know that a fire hose could be spewing like this. It's a lot. The learning curve is steep, as you said. There's a lot that I'm learning, and my practice was pretty varied, but I'm encountering things that I've never encountered before. I'm encountering technology I've never used before. And I'm definitely working long hours. What I've been told, though, as you said, 4 to 5 months. Someone told me 6 months is how long it takes until you sort of feel like you've eased into it. I guess we'll have to do an update, and I'll let everybody know if that's true.
Yeah, you have to keep in mind, I mean, none of us are generalists anymore, right? You either work in criminal practice or domestic practice or civil. And if you're in civil, you could be one of 10 different, areas of expertise. When you become a judge, you've got to learn it all. And I know I was a civil practitioner. I thought I knew most that there was to know about civil practitioner. No. I mean, I sort of felt like there was about 30% of the civil stuff that was sort of that I was comfortable with. But the rest of it was new. All the domestic is new. The criminal is new. So while I think this is a rewarding job, and I would urge people to apply, don't have any, misunderstanding about what you're applying for. It's difficult. Justice Hagen, from the appellate perspective?
When you say 6 months, people told me a year to 2 years. I mean, a year to 2 years. It was 18 months before I felt like I had seen most things. And maybe that's because of the pace, too. Maybe you see all the different kinds of cases faster in the district court. But at about 18 months, I finally started going home earlier than 9:30 every night. But the working nights and weekends really never stopped. We had a really heavy caseload on the Court of Appeals. On the Supreme Court, I felt like I couldn't even often touch my opinions during the day because there were so many meetings and committee things and administrative things to take care of, and then I would work on opinions at night and on the weekends. So that's really true. I mean, this is not a job you go to if you don't want to actually do the work and work hard. But I will say, as for that question about, there's a steep learning curve and you think you maybe know these general areas of law, but you find out that there's so many that you've never touched. I got a little discouraged when I first started at the Court of Appeals, thinking I was not prepared for this. I did not realize how broad, the administrative issues, juvenile court, domestic law, property law. And I got really great advice from Judge Christensen Forrester, who's told me that she said, you are as prepared for this job as any attorney who has ever been appointed to the court, because every single attorney has gaps. We're all specialists. Even if we have a fairly broad practice, there are lots of areas that you don't know, and you can do this just like every other judge who has ever been appointed. It's just a learning curve, and you're capable of doing it. And that really reassured me and let me feel like, no, it's okay that I don't know these things right now, because nobody knows everything right when they take the bench. And so if you feel that and you feel that hesitation to becoming a judge, don't worry. We all went through it. We all learned it, and you can too.
All right. One of the other challenges of being a judge is that you give up some of your rights when you become a judge. You can't be involved in certain community activities, in politics, certain nonprofit work. We can't have lawn signs. We can't donate to political, because we have to maintain the integrity of the judiciary. I have joked over the last 8 or so years that that's the best part of my job, because when somebody wants to talk politics, I say, I can't talk politics. But it does really have an impact on the way that you handle yourself. Judge Torgerson, how have you handled this?
It's a tricky thing in the modern world with modern technology because the least informed people are usually the loudest, and they tend to have lots of people who glom onto their opinion of the world, and they're typically uninformed about how the court process works. And I think, we have a prohibition against commenting on pending and impending cases, and there's different definitions for what those are, and they're not very clear definitions. And I think the court's historical practice has typically been, stay silent, let your work speak for itself. And I think that's wise, not just as a way to proceed as a judge, but also it helps us comport with those requirements that we not comment when we shouldn't be commenting. But it's tough because, people comment and people say things, and but it's a cycle that you can't win as a judge. We don't have in the judiciary access to the kinds of PR campaigns, and we don't have access to the news media outlets in the way that other people might. And, there are judges in other jurisdictions that have social media accounts, and I think they do some really good work with those social media accounts. They talk about the judiciary, they inform people about the judiciary. Those are typically jurisdictions, though, that are elected position judges, and so that's part of their campaigning. We've considered whether we should do more of that at the judiciary, whether that would be informative and helpful. Whether that happens or not in the future, I still would rather have the appointment process that we have in Utah over the elected judiciary that they have in other locations. I think it's a better process. And if the trade-off is, we tend to be more silent and we tend to not be able to fight back against criticism quite the way that maybe other places could, I still think that's a worthy trade-off.
Justice Hagen, in your mind, why is it important to remain above the fray, so to speak, as much as possible?
Because the courts really speak through their opinions, and because we're not a representative elected branch of government, we're not designed to respond to public criticism or public clamor about certain issues. And we also need to speak with an official voice. If we are commenting on our decisions or the operations of the court, and it conflicts with something that we've put in our opinions, which is binding law, that's going to be a problem as well. But we do sometimes try to respond to things in our actual opinions. We had one case where when we issued a second opinion in the same case, we took some time to explain our first opinion because it had been misconstrued in certain ways. And we will sometimes respond to things within the opinion itself, but we just need to make sure that the entire court has signed off on that language, that we all agree on that, so that we're consistent and that we don't cause any confusion. And we also want to maintain the dignity of the court as well. We are not politicians, and we don't want to be dragged into the fray in that same way. We want to maintain the public's trust and our integrity.
Judge Kuendig, how are you making this transition?
The transition's been interesting. I'm trying to pick my words carefully. Let me start by saying that everybody that works within the courts, including my colleagues, have been so welcoming and helpful as I make this jump with the fire hose pointed directly at me. As for how it's affecting my non-work life, though, I'm still learning how to extricate myself politely from conversations, which surprisingly come up at the gym more often than most places. The one place where you sort of don't want to be talking. But, I think that there's a way to be polite and to, explain that I can't have certain discussions or I can't be involved in that discussion without hurting someone's feelings or making them feel slighted in any way. And, I'll just keep working on learning how to be a member of the community in this new role, because it is different.
Yes, it is. Another challenge, as we live in a more technologically advanced society, and as we are now, it seems, in a time where people have access to social media and to criticize judges, and it's a very different world, as you know, than we lived in a couple of years ago. There's been a dramatic increase in threats made to state and federal judges, and judges at all levels have been subject to online attacks, and I guess I don't know if that's something that the general community of lawyers knows about or thinks about, but Judge Torgerson, what can you tell us about those issues?
It's a real problem. I don't remember the last numbers we got. Just under 1,000 threats last year against judicial officers. Yeah. So just under 1,000 threats against Utah judicial officers last year. And some of those are scarier than others, certainly, but they're threats that are significant enough for us to count. And, you know, it's a concerning thing. I have, you know, some of our courthouses, especially in rural courthouses, we don't have secure parking necessarily. So the other problem, though, is I'm a judge in a district where I practiced and grew up. And so I know lots of people. And so they approach me at church, and they approach me at Walmart, and they approach me at the gas station, and they know where I live. Some people have come to my house and knocked on the door, people that I don't know but happen to know where I lived, and said, hey, you know, this protective order that one of your colleagues issued needs to go away. And I don't know where he lives, but I knew where you live. And so it should go away right now. And I'm like, well, you know, you really should be the one going away. I think rural judges have a different experience than urban judges, because we're at soccer games and high school sports and those kinds of things where we see people all the time who are appearing before us as litigants, and it's kind of a tricky thing to navigate. I don't generally feel unsafe, and I think part of why I don't generally feel unsafe is because I am a male. A practical reality of this job is that women receive far more serious threats as judicial officers than men. And I think that's a sad commentary on kind of our world that we live in. But for some reason, people believe that women as judicial officers deserve to get the kinds of threats that have nothing to do with their cases, have everything to do with their gender. And I don't get those kinds of threats. I get told that I'm dumb and, you know, stupid and shouldn't be on the bench and those kinds of things, which I'm fine with. But the really scary threats tend to be, I think, made against women in judicial officer positions. And so we have a great court security officer, best there is. He is monitoring those threats. He is in contact regularly with law enforcement in our areas to make sure that we are aware of any threats that might be coming. We take precautions. You know, we try and do things to minimize the threats overall. But, you know, I don't feel super unsafe in this job, but there are times that I take extra precautions when I feel like it's warranted.
Justice Hagen, any thoughts from you on that?
I don't have much to add other than to agree. Our court security director, Chris Palmer, who's here, is amazing, and he's very proactive in monitoring things that are going on with the judiciary. The courts will take steps to implement protective measures when it's necessary. You can always be assured that the court's going to have your back on those things. Before we issued some controversial opinions a couple years ago, we spent about 6 months having Chris got a third-party system to go through and scrub all of our addresses and personal information off the web, so that we would have less of a chance of having a doxing problem or what some other judges in the United States have experienced with swatting, where someone sends a SWAT team to your house saying that there's a hostage situation and different things of that nature. So I have felt safe as a judge. I felt like the court had my back, and that I was not afraid for my physical safety or that of my children. Now, that does not mean that there have not been invasions of privacy. that is difficult, and that is something that it's really difficult for the court to protect you against.
Judge Kuendig, did you even know about this when you applied?
I actually did. Not to the extent that I know now, but I did. And what I would add on this topic is that what we do matters, and I don't just mean judges and the judiciary, but everybody in the legal community, everybody sitting in this room. What we do matters. That our separation of powers, this is beautiful, delicate balance that was created from the outset, and we are all part of that third leg of the three-legged stool, and we're humans. And as humans, we're going to go through things, and we're going to have, times that are bad, and we're going to have things to be afraid of. But I really felt when I was pursuing this, knowing what I was, to a certain extent, getting myself into, there was two things I could do, and both were the word fear. Either F it and run, or face everything and rise. And if we don't face everything and rise, then what happens to that third leg of the stool? So I say that now, it's easy. I haven't had one of these things happen to me. But I'll just go back to what we do really matters, and so I decided to apply anyways.
Let's talk about high-profile cases. I think there's an irony here. The high-profile cases are the cases that sort of drive community expectations and awareness of the judiciary. But at the end of the day, there are so few of these cases. And those seem to be the drivers for a lot of the things that we hear about in the news and about the legislative reaction to the judiciary and that sort of thing. I will tell you, I practiced for 13 and a half years. I had cameras in my courtroom. There was one election case that you've never heard of. A couple of criminal cases, one that was a high-profile criminal case, but that's it. When I was on the 3rd District, I had 1,000 cases assigned to me. So the number of cases that generate publicity and generate this awareness by everybody is so small. It's so low, and it's sort of an irony that those are the ones that seem to drive a lot of the things that we have to deal with. Judge Torgerson, high-profile cases. What do you have to say about that? The number of cases that we have, most of the cases we have are so much more boring than these high-profile cases. That's really not what we do. We have thousands of collection cases and divorces and evictions and contract disputes. And of the criminal cases that we have, most aren't newsworthy, really. I mean, occasionally you will have one, but it's just such a small number. And the number of cases, of course, these constitutional challenges, you're talking about one or two every few years. I mean, it's a very, very small number. And so, if you are thinking of applying, but you say, boy, I just can't deal with the media, and I can't, it's really such a small portion of what we do. Judge Torgerson?
There are, and court security would know better how many there are because they're taking care of them from a security side. But there aren't very many, and they're usually the ones that will be high profile from the minute they land. And we have lots of experienced judges who've dealt with high-profile cases in the past. We train judges on high-profile cases at our conferences, just to say, look, we have decorum orders for you to put into place that you can use to manage your high-profile case if you happen to be the unfortunate soul that draws that case. The real problem is the ones that we don't know are going to be high profile, right? The one that evolves last minute. And when I got popular on the internet, it was it was a routine thing. And, I'm in the news a lot in my rural district because what's happening in the courtroom is the most interesting thing that's happening. And so we are in the local paper. I don't think that makes those cases high profile necessarily, right? There are really very few of them. And, do we spend more time on them? I think they get the time that they need, just like any other case gets the time that it needs. They get more security involvement. They have IT more involved because they might crash the WebEx. But as far as the amount of effort that the judicial officer puts into that case, we're aware of it enough to manage it, but it gets the amount of work and the amount of effort that every other case gets because we're there to resolve that dispute the same way.
Judge Kuendig, have you had a case involving any media requests yet?
I have not.
Okay. Well, you will. I mean,
But I think it goes to your point, very few of the cases involve media, involve anything high profile. I've been doing this for 4 weeks and have, however many hundreds or 1,000 cases, and the majority of the cases are, individuals, pro se parties, people, companies, not necessarily, it matters to them, but it doesn't necessarily matter to the public at large.
Right. And the district court, we are administering so many cases. We've got to get them, we've got to decide them, and we have to move on.
Yeah.
Justice Hagen, obviously things are a little different up on the 5th floor in the Matheson Courthouse. How do you folks go about dealing with? And I guess a much higher percentage of your cases are going to care. People in the community are going to care about it.
Absolutely. Although, there's a lot of cases that we take that perhaps the insurance industry cares deeply about the case, or the plaintiff's bar, or some specific group that the way we're going to answer this unresolved question is going to affect pretty dramatically. But even in the high profile cases, often, people have the misconception that we are trying to decide the ultimate issue, like whether something should be legal or something should be against the Constitution, and we're usually deciding a very, very narrow issue. We're often arguing over very arcane procedural issues of preservation or whether we have a prudential rule against reaching something. I mean, it's not as, all of our issues are not as sexy as people might think. Even in the cases that draw a lot of attention, we're often deciding a very narrow question of law. But we do have to deal with the publicity sometimes before we issue a case that we know is going to cause a lot of controversy. We will alert our court security director. We will have sort of procedures in place to deal with the media inquiries that come in, that sort of thing. But the courts do a really good job of managing that for us.
So the integrity of the courts is premised on judicial independence. Have you ever been in a position where you felt compelled to decide a case in a certain way because of public perception, opinion, or political pressure? I will start by saying, of course, there are cases where you feel it and you're aware of it, and our job is to ignore that and to make the determination on the merits of the case. And it's easy for me to say because I'm retired now, and so I don't have to worry about that anymore. But it is real. It is palpable. You can if you're in a case, if there is a certain public perception or that there may be a group hoping that this goes one way or another. You're sort of aware of it, but at least in my mind, we are sworn not to do that. But it's becoming more challenging, and Judge Torgerson, you know this about as well as anybody.
We have a judicial canon, 2.2. Anyway, it says that we're not to take into consideration any outside views of things when we make our decisions. For the most part, I find that to be a fairly easy canon to apply. There are times, though, that I catch myself, and I think, am I doing this thing, whatever it is? Maybe it's maybe it's a sentencing, maybe it's a motion for summary judgment. Am I doing this thing because it's the right outcome, or am I doing this thing because it's the outcome that's the least painful for everybody. And I think we as judges have to make sometimes a conscious effort to remember to do things because it's the right outcome. And I think every judge that I've ever met does that. I have yet to meet someone who has made a decision because it was the expedient decision rather than the right decision. It's often that our decisions are make somebody unhappy. That's unfortunately the reality of litigation in the courtroom. Everybody loses. Well, not everybody loses, but often everybody loses, right? I was told a long time ago that if I have a domestic case and everybody leaves unhappy, it means I've done the right job. And sometimes that's true. And I think we have to, as judges, follow that canon very closely, that regardless of how much public clamor there may be, and regardless of what the people in the room may think we should be doing, that we are applying the law in a fair and just way for everybody. Because if you can imagine a scenario where someone in a position of authority or influence could come into the courtroom against someone who didn't have that authority and influence on a property case, for example, and those parties felt like the person with authority and influence would win simply because of their position and status in the community, that would be a pretty disheartening place to be, the person without that authority and influence. To know that you were going to litigate a case where you might have the right law on your side, but you would lose that case because you weren't the powerful party, that would disrupt, I think, our entire system. And so to know that our judiciary, and I think our judiciary does this, to know that our judiciary applies the law fairly regardless of public clamor, regardless of who might be in front of us and what their position and status might be, I think hopefully gives courtroom litigants at least a feel that they have a fair chance to be heard, to get due process, and to have a decision that's fairly made on the merits.
Judge Kuendig, have you come up with it? Have you felt this at all yet?
I mean, not in the grander, I guess, public context, but, I think anytime someone has come before me and they're arguing zealously, in your head, you do think to yourself, well, if I do this, this could happen. If I do this, this could happen. That's a natural part of the thought process that's similar to, I think, what Judge Torgerson is talking about. And that's what we have to set aside. But just like with any bias, with any thought that comes into your head, it's actually, I think, easier to set it aside when you're conscious of it. And when we're conscious of what that pressure is, then we can put that aside and do what we've been sworn to do, which is to ignore it and to just apply the law, however the law and whatever the outcome is, the outcome is.
Yeah. I think this concept comes up in criminal sentencings, where you're presented with two options. Do I send this person to prison? Do I give them another chance? And you know that if you give them another chance and they reoffend, and somebody gets hurt, that it's going to come back to you. And that's a palpable thing. You can feel that. I don't think that this sort of public nature of our job has changed the way that my decision, but I say less. One of the things that I think that we've learned is the more you say, the more you can get in trouble. And when we are on the bench for 8 hours dealing with criminal matters, we don't have an 8-hour script. We are talking, we are saying things that may be entirely appropriate and well-intended, but taken the wrong way. And so that is one thing that I think we're probably all very conscious of when we're speaking, because everything that we do is public speaking by definition. Just Hagen, you guys have a lot more cases where there might be these sorts of pressures from the appellate perspective. What say you?
One of the interesting things, though, that distinguishes our court from the district court is that we don't have a lot of discretion. We don't make a lot of discretionary decisions where you really do have a multitude of choices. We're almost always dealing with legal issues. And I alluded to this earlier, that we're not looking at should something be a particular way. So in terms of public clamor, I can tell you that the most blowback I ever got from my family is when the Supreme Court held that fly fishermen did not have a constitutional right to walk up stream beds. They were like, what? Fishermen should have the right to walk up stream beds. And I thought, why? I don't have any problem with it if the legislature wants to, allow you to walk up stream beds. It was a common law easement, but the legislature's limited that. And what we were deciding wasn't whether it's a good idea for fly fishermen to walk up stream beds, or whether it's not a good idea, or whether we think that it should be allowed. We were trying to decide whether it was in some provision of the Constitution and limited the legislature's ability to do that. And that also makes it much easier for me. I give this example all the time to when I have school groups come into the court. And it's one of my favorite things, because I think people misunderstand how we make decisions. But early on, when I was on the Court of Appeals, I was asked to sit with the Supreme Court because there were some recusals. And the case was about school board elections. And for a long time, school board elections were nonpartisan. And the legislature had changed the law so that they were partisan. And a group sued and said that violated the Constitution. And I think that the way that most people see these cases is that we were deciding whether it was a good idea for school board elections to be partisan or not, or whether they should be partisan or not. But actually the issue in that case, we had to zero in on what the plaintiffs were arguing, which was there's a provision in the Constitution that says there shall be no partisan test for employment in Utah's public schools. And the only question we had to answer is, what is the meaning of the word employment, and whether elected school board officials are employees of the public school system. Now, as a judge, when I zero in on that question, I can kind of push everything else out. I'm not thinking about whether it's a good idea or whether school board officers should be partisan. I'm just trying to decide whether they are employees of the school district, and that's how we decided the case. And so when people understand what we're actually looking at, and of course you as lawyers understand that when we're trying to decide if something's constitutional or unconstitutional, we're looking at whether it exceeds the legislature's or the executive branch's ability to make a decision because of a particular provision of the Constitution. I truly believe most of the general public thinks that what unconstitutional means is that it's really unfair or a really bad policy idea. But we all know that we're actually applying an actual provisions and actual language. And when you zero in on the real job of deciding the case, I think it is, for me at least, it was fairly easy to not listen to public clamor, because really that debate is about something else. That debate is about shoulds, not what the law requires.
So we've talked about the challenges. It's hard work. You give up your social life. You're subject to public criticism. So let's go through each one of us and tell everybody why they should nonetheless apply to be a judge. Judge Kuendig?
I talked a little bit about this earlier. Our system is a system of human beings. When you're a lawyer in the system, you're human. Judges are human. And the system works the best when those that care and those that are conscientious and those that are ethical do the work. And so I just encourage everybody, don't self-select out. It's easy to say to ourselves, well, it's not going to be me. It's only not going to be you if you never throw your hat in the ring. But if you're one of those conscientious lawyers that is thinking about applying, at least let the process work and give yourself that chance, because the system is human and we need good humans.
Judge Torgerson?
We need good humans. I think that says a lot. When I was in law school, I liked law school. I liked the research and the writing and the deciding hard legal issues. And in practice, unfortunately, a lot of practice, at least my practice, was putting out fires and not really dealing with the legal issues. It was more strategy and how do we present this thing, but ultimately money often, or time, often limited how much time I could spend figuring out the result that I was trying to reach for my client. And on the bench, I don't know that I have more time, but my time is structured in a different way. And so I get to spend time critically thinking about legal issues that are important and thinking about the right result. And it's not driven by a client who needs to get an outcome. It's driven by the right result. And I think that's a very satisfying thing, to try and come to the right outcome and reach the right result, because I maintain that this is the best job in law. If you interact with the courtroom in your practice in any way, this is the best way to interact with the courtroom. It's just it's interesting, new issues every day that I never expected. Dealing with people who experience extreme hardship can be very satisfying in our treatment courts. Working with the public in a different way and hoping that you're delivering to them a fair process, that they feel like they're heard and that they're experiencing the courts in a way that is satisfying to them, even if they don't get the outcome that they wanted, that they at least felt like they were heard. I think judges have a big part in all of that, to deliver access to justice to people who need access to justice. And that's very satisfying to me. So I would say, we do need good people. We need people who are willing to apply the law without regard to the public clamor. And we need people who are willing to apply the law the right way and give people the access that they come to court to receive. So I would do it again. I think it is very satisfying work, even though sometimes it can be tremendously difficult work.
Just Hagen?
It is really an incredibly rewarding job. You feel like you're making an impact in terms of applying the law, advancing the law. As an appellate practitioner most of my career, I felt like I could envision how appellate judges could write opinions to clarify legal concepts, to make it easy for district court judges and practitioners to apply, to increase predictability and consistency for litigants. And you have the opportunity to do those kinds of things as a judge, is to write the kinds of opinions that you knew would be useful to you as a practitioner, and to really have an impact beyond an individual case on the overall development of the law in Utah. So that's incredibly rewarding. One thing that I don't think has been mentioned yet, and perhaps it's because my career has been on collaborative courts as well, that the people that you get to work with are absolutely amazing. I mean, my colleagues on the Court of Appeals, my colleagues on the Supreme Court, I could not have ever hoped for more brilliant, kind, thoughtful, engaging people that made me a better judge and a better person. And that was, I mean, there's no replacement for that. And then the other thing I loved about the job is that it did give a platform to educate the public, to educate school groups on civics. It was my favorite part of the job. Speaking in CLEs like this is wonderful, but speaking to community groups and all of the students who toured the courthouse and participating in these All Rise events to try to get more people interested in the judiciary and more wonderful graduates to stay in this amazing legal community, all of that is incredibly rewarding. And that's an opportunity that really opens up to you as a judge. Of course, we can all do it at whatever level we are. We can do that kind of mentoring and sponsorship and make the legal community a better place. But I really felt that, particularly on the Supreme Court, that I had a lot of ability to influence our practice here, our community here, and the rule of law. And so, and in a way that you just really can't affect in any other position. So I think it's an incredibly rewarding job. And I would absolutely apply for the Court of Appeals again if I had to do it over again. Did you catch that?
I would mimic what they said. I mean, I've just retired after a 13-and-a-half-year stint. It was so far beyond what I would have ever thought I could do when I graduated law school. It's an incredibly interesting job. It's incredibly rewarding and fulfilling. The best part of being a judge is interacting with the other judges, both in our district, but we have conferences twice a year where we go someplace and we meet with the judges from around the state, and it's just incredibly, they're just a great bunch of people. And so you get a lot of help as a judge from within your bench and the camaraderie among the judges, and it's a terrific job. It is not without its warts, and as I said, it's a hard job. But I would do it again in a second. I wouldn't think twice about it. I do want to make one other comment. I think it's somewhat of a truism to say that the judiciary is more credible the more it mirrors our community. And so it's really important that we have a diverse bench. And especially in the 3rd District, where we have a diverse community. And the only way that we're going to enhance that is to get people from diverse backgrounds to apply. And I think that's really important. Again, I mean, people come in and they see us as the, we are the judiciary. We are the branch of government. And if they see everybody that looks like me when they don't look like me, I think we're less credible. And so what I would ask is not only for people to apply. If you're willing to work hard and if you meet the requirements, I would urge you to apply. But I'd urge people from diverse backgrounds to apply, because we really, I think, as a judiciary, I think we need that. And I think it goes without saying that the more diverse we are, the stronger we are. So does anybody else have anything they'd like to say? All right. There you have it. Thank you.